Hi, everyone. Welcome to the League of Women Voters of Moscow Speaker Series. I'm Kylie Breitzman, and today we have Don Burnett, who's organized our talk with our two speakers. So I am going to turn it over to him for introductions for today's talk. What I want to note is I'll be moderating the chat. So if you think of questions for our speakers, please feel free to just type them in the chat as they are talking so that you don't forget your question for later. So just add those in the chat. We'll be moderating it and make sure that those questions are asked at the end of their presentations. We should have about 10 minutes or so for Q&A before we wrap up at 1 o'clock. So I will turn it over to Don, who will be introducing our speakers. And thanks everyone, as always, for joining us today.
Yes, thank you, Kylie, and thanks to everyone and to all those who are connecting either now or in a viewing of our recorded session. If you're at the University of Idaho or anywhere in the Moscow vicinity, welcome to Indian country. This is ancestral homeland of the Nez Perce, and we are proud to have a Native American law program here, which is regionally and nationally recognized. We wish that discussions of public issues in the public forum more often made reference to Native perspectives and listen to Native voices. Today, we're just going to take an introductory approach to three important issue areas by way of consciousness raising. We're going to introduce the general subject of treaties and tribal sovereignty vis-a-vis the powers of the states in our system of government. We're going to look at the tribal heritage of Native children as potentially impacted by current litigation in the U.S. Supreme Court challenging the Federal Indian Child Welfare Act, known as ICWA. And we're going to take an introductory look at the authority of tribes to enforce the Federal Violence Against Women Act, sometimes known as VAWA, particularly with respect to the authority of tribes to take action against non-Indian perpetrators of violence against Native women in Indian country. Our speakers are distinguished members of our faculty here at the University of Idaho. Dylan Hedden-Nicely is a citizen of the Cherokee Nation of Oklahoma, is an associate professor and the director of the University of Idaho College of Law's Native American Law program. He graduated magna cum laude from our law school with an emphasis in Native American law as well as natural resources and environmental law. He chairs the Idaho State Bar's Indian Law section and sits on the governing council of the Northwest Indian Bar Association. Professor Neusha Romer is an assistant professor here at the University of Idaho College of Law. She teaches courses in family law and Native American law. She's a graduate of the University of New Mexico School of Law, which is one of the premier sites of Native American legal education. She earned a Law and Indigenous Peoples certificate at that law school and also served as a member of the Tribal Law Journal Board. So we will turn the time initially over for our first topic to Professor Hedden-Nicely, and then we will turn subsequently to Professor Neusha Romer to discuss our second issues regarding ICWA and VAWA. So Professor Hedden-Nicely, the virtual podium is yours.
Well, thanks, Don. Greetings, everyone. As Don mentioned, my name is Dylan Hedden-Nicely. I am a citizen of the Cherokee Nation and an associate professor where I direct our Native American law program. And I'm so thrilled to be here to present this material to you today. Don has had a lot of titles throughout his illustrious career, but I will always know him as Dean Burnett because when I was at the law school, that was the position that he held. And as a general rule of thumb, you usually don't tell your dean no. So when he asked me if I was willing to participate in this, I was glad to do it. Although I will have to, all joking aside, even though Don is ostensibly retired, the amazing work that he continues to do is truly inspiring. And so I'm always thrilled to help whenever I get the chance. I'm also really thrilled to be presenting to the League of Women Voters. It's my honor. I was raised by my mother, who's on this call, who was a member of the League of Women Voters in Ada County for many years. And I've always held this organization in such high esteem, particularly for the role that you guys play in protecting the democracy within the state of Idaho. So thank you very much for having me. I'm going to try to share my screen here really quickly. Let's see if I can get lucky here.
We see it.
Okay, and then I need to flip this. Okay, so now you should be looking at the presentation view, not my notes. Okay, great. So what I'm going to be talking a little bit today about is just tribes, tribal sovereignty, and how tribes fit into our American system of government. And so when I was in high school here in the state of Idaho, I was taught that the American government looks something like this. It's the interrelationship between a group of states and the federal government. We have this concept of federalism, which divides power between these two sets of governments. But of course, that doesn't tell the entire story, even at the time that we were forming our governmental structure, and indeed for millennia prior to that. The continent looked something more like this, right? We had a continent that was full of, as Justice John Marshall acknowledged in 1832, by distinct peoples divided into separate nations, independent of each other, as well as the rest of the world, having institutions of their own and governing themselves by their own laws. And Idaho was just the exact same as this. And so as recently as 1855, Idaho looks something like this, where we have the Kootenai tribe, or the Kootenai Nation, holding Aboriginal title to the land in the very northern portion of what is today Idaho. And the Kalispels and the Pend Oreilles occupied a territory just south of them, followed by the Coeur d'Alene tribe, which today lives just to the north of us here in Moscow. And then just to the south of the Coeur d'Alenes are the Nez Perce, which is where we are currently situated right at this moment, was within the homelands of the Nez Perce tribe. And then southern Idaho in its entirety was owned and occupied and controlled by the Shoshone, Bannock, and Paiute peoples, over 55 million acres of land. Today, we recognize the state of Idaho as looking something more like this, where we have the exterior boundaries of the state, and within the state, we have 5 different Indian reservations. So to start, once again, starting in the north, the Kootenai Reservation, Coeur d'Alene Reservation, Nez Perce Reservation, and then all the way down here in the south western portion of the state is Duck Valley, home to the Shoshone and Paiute peoples. And then in eastern Idaho, we have Fort Hall Reservation, which is home to the Shoshone and Bannock peoples. So the question is, well, how did we get to this point? How did we get to the point where tribes went from owning essentially all of the land of the United States to having these reservations of land and reservations of rights? And there's a sustaining myth within our country that the answer is conquest, that the United States government and non-native people were able to sort of overrun the continent, appropriate the land, and then give rights and give land back to the tribes. But it's actually the exact opposite that occurred. To be sure, there were Indian wars, and there were situations where Indian people were subjugated, but overwhelmingly, the way that tribes and the United States acquired land from tribes was through bilateral agreements between tribes and the United States. So this and up until, for the majority of the history of our country, the form of the agreement that was used were treaties. Now, that's important for 2 reasons, for our purposes anyways. For one, it demonstrates that European countries at first, and then later the United States, recognize tribes as sovereigns. Treaties are agreements between sovereigns. That's the only time where treaties are appropriate to be used to memorialize an agreement. The other thing that these treaties are important for is because they memorialize the terms of the deal that the tribes entered into and the United States entered into. And so what the tribes were willing to cede away, as well as what the tribes reserved. And so starting with that second point, the Supreme Court has long recognized that, consistent with what I've just explained to you, and this is a quote from a case from 1908 in the United States Supreme Court, that the tribes had command of all of the lands and waters, command of all of their beneficial uses, whether kept for hunting, grazing, roving herds of stock, or turned to agriculture and the arts of civilization. In other words, they owned the land, they had control over the land, they had control over the people that were coming onto the land. And therefore, what the treaty was, what these treaties were, was not a grant of rights to the tribes from the United States, but a grant of rights from them, as well as a reservation of those not granted. It's a really important point to keep in mind. That's why tribal homelands are called reservations, because it was the land, the portion of their homelands that they reserved unto themselves, lands that they've always owned. And that ownership has been unbroken since time immemorial. And so let me give you an example of that from right here in our own backyard with the Nez Perce tribe. And so this map here shows in the crosshatched area, the tribe's Aboriginal territory, or the land that the tribe historically owned and occupied. It's approximately 17 million acres of land. It includes essentially all of north central Idaho, including right where we are right now in Moscow. But it also included portions of southwestern or southeastern Washington, as well as northeastern Oregon. And even though this map doesn't show it, the Nez Perce tribe had a very strong and regular presence in western Montana as well. In 1855, the United States came to the tribe and requested that they negotiate a treaty for the cession of some of their land, which they agreed to do. They agreed to cede all of the land outside of this red line that says 1855 right here. And so all of this land outside of the reservation was ceded to the United States. All of the land inside that reservation, land that it had owned and occupied since time immemorial, continued to be held by the tribe. Now, there was subsequent cessions in subsequent treaties, but I want to focus in on this one right here, this 1855 treaty. They ceded 9.5 million acres of that 17 million acre reservation. So the question is, well, what did they get in return for that cession of 9.5 million acres? Well, one thing that they got was they were paid a nominal amount of money, $200,000 to be exact. If you do the math on that, that amounts to approximately 2 cents per acre of land. And so obviously the money was not the basis of the bargain. It was not the thing that was the most important thing to the tribe. And so what was? Well, we could talk about Article 2 and all of the hunting and fishing rights that were reserved to the tribe, both inside and outside of the reservation, things that the tribe specifically requested so that they could continue to live according to their own way of life. We could talk about the schools that the United States promised, the various other agricultural implements to try to support the tribe as it developed a new economy while also keeping a hold of its old one. But the one that I want to focus in on here, because time is of the essence, is this promise in Article 2 that the 7.5 million acres that the tribe did reserve in 1855 would be reserved as a permanent homeland for the exclusive use and benefit of the tribe. And this right here is a pattern that we see over and over and over again. in exchange for ceding vast tracts of land to the United States, what the tribes all over this country primarily were negotiating for was an area that they can keep to themselves and have as their permanent homeland. And so, for example, in Idaho, we have the Coeur d'Alene Reservation. The United States agreed that the Coeur d'Alene Reservation shall be held forever as Indian land and as homes for the Coeur d'Alene Indians. I've already talked about Nez Perce. Down here, Duck Valley was to be set apart as a reservation for the use of for the ownership and use of the Western Shoshone. And then also over here, Fort Hall was to be set aside as the Shoshone Bannocks' permanent home. Now, permanent home, a homeland, is not the same thing as like a home as we think about it. It's not just a place where these folks would live. Instead, what the Supreme Court has said in interpreting the Navajo Treaty, 1868 Navajo Treaty, is that the right to a permanent home included from the very first days of our government the right for the tribes to govern themselves, free from state intervention. And then earlier on, the court, in interpreting that exact same homeland language, found that implicit in those treaty terms was the understanding that the internal affairs of the Indians remained exclusively within the jurisdiction of the tribe's own government. And so, what you can see here is what the tribes were negotiating for was an area within which they could continue to live their own way of life according to their own laws and their own customs. Now, what have tribal governments done with all of this power? And that's the last thing I want to talk about. So tribes as governments are extremely active in Idaho and all over the country. So here's just a couple of, just to familiarize ourselves with some of the governments that are directly adjacent to us. In the top here, we have the Coeur d'Alene Tribal Council. It's a 7-person council. And it is run by a chairperson. In this case right now, that chairperson is Chairman Chief Haaland. And so they have something that's more akin to a parliamentary system whereby the executive is housed within the legislative branch. And then they also have a separate judicial branch. And we'll talk about tribal courts here in just a moment. Just to the south of us, the Nez Perce Tribe's Executive Committee is comprised of 9 members, and it also has the same governmental structure with a chairman, or a chairperson, I should say, of the committee. And right now, that chairperson is Chairman Penny, Sam Penny. And so this is the structure that we also see at the Shoshone Bannocks, as well as the Kootenai Tribe of Idaho. But other tribes have traditional 3-part, and by traditional, I mean traditional American 3-part governmental systems where you have an executive branch that is completely separated from the tribal council. The Cherokee Nation, my tribe, is that way. And then they have a tribal council as well as a judicial branch. Navajo Nation is also that way. Other tribes have very traditional governmental structures that are based much more strongly in how their governmental structures operated before Europeans arrived. And so we have somewhere in the neighborhood of, it's hard to keep track because tribes keep getting recognized, but 576 tribes throughout the country, and each one has a unique governmental structure. Tribes also have tribal courts. This is the Fort Hall Justice Center down in at Fort Hall in southeastern Idaho. The inside of it looks like this. It looks just like a state or federal court, and the proceedings in this look just like the proceedings in a state or federal court. Other court systems other tribal court systems might look totally different, but most of the tribal courts within the state of Idaho very much look like a traditional Western or American court system. Tribes also have law enforcement as well as emergency services. And so all of the police officers or all of the tribal police within the state of Idaho are either certified through the state of Idaho's Post Academy, the Police Officer Standards and Training Academy, or the Federal Law Enforcement Training Centers. Some of our tribes provide urban fire suppression. All of them provide wildland fire suppression. Some of them provide emergency medical services. As governments, they provide medical services. This is Mariman Health up on the Coeur d'Alene Reservation. This is both the traditional IHS or Indian Health Services facility. It's also a community health center, so it services both tribal members as well as non-member community members as well, about 50-50. And it actually is the largest medical center between Coeur d'Alene and Moscow, and serves most of that area, including the area around St. Mary's. They provide medical, dental, vision, as well as behavioral health at Mariman, and the suite of offerings grows constantly. Tribes as governments provide education. This is from Chief Tagee Elementary at Fort Hall, but there's also Lapwai High. Nez Perce tribe has an elementary school. The Coeur d'Alene tribe has a tribal school, and so each of these tribes provides educational opportunities for their membership, as well as providing a substantial amount of support to the state-run education system as well. This is, I believe, close to my last slide, so I'm moving on, but tribes also are very involved in infrastructure development. Tribal areas and reservations have some of the lowest rates of internet connectivity in the country. And so tribes have taken it upon themselves to start to build out that infrastructure. And so, for example, on the Coeur d'Alene Reservation, they have Red Spectrum Internet, which is a tribal-run internet service provider. In addition to that, tribes are engaged in just traditional infrastructure building. This is a picture from the Duck Valley Reservation, where they're developing a road, and they're developing a housing project, including building all of the roads, sewer, power, everything else that is involved in that. Project as well. And so what I want to leave you with is that I hope that you come away convinced of is that this is not necessarily the appropriate way to be thinking about American laws and American government. Instead, we should be thinking about it much more like this, where American law, the laws of the United States include state, federal, as well as tribal laws. And we should be examining the interrelationship between these three governments as well as their laws. And so I think I am out of time, but I'll look forward to the discussion after Professor Romer finishes. And I just want to say, Wado, thank you very much. And I'll turn it over to you, Professor Romer. I'll stop my share. There you go.
Hi, everyone. As Don said, my name is Neosha Romer, and I am a professor at the University of Idaho College of Law. Today, I'm going to be talking about the Indian Child Welfare Act, which, really comes, I think, it flows very well from the end of Professor Hedden-Nicely's presentation on this interaction between the federal government, state government, and tribal governments, particularly in the area of families, which is what I'm going to be focusing on. But I do want to start out by saying something, because I know the title of today's presentation is Native Voices and Tribal Perspectives. And I just wanted to point out that I'm not myself a tribal member. But the reason that I study this issue, the reason that I've done work in this area, and the reason that I'm here today to speak to you all is because this really goes back to that interrelation between federal, state, tribal governments, and what our state courts and our federal government are responsible for when it comes to promoting not only tribal sovereignty, but also, making sure that we aren't, if you will, willy-nilly tearing families apart to achieve goals of assimilation and causing further cultural and structural harm in Indigenous communities in the U.S. So just for some background, why the Indian Child Welfare Act exists in the first place. So there is a pretty sordid history of the federal government having policies that essentially led to somewhere between 25 to 35% of all Indian children being removed from their homes by the mid-1970s. Those two are the main two things that I would focus on today would be the boarding schools. So starting in the late 19th century, the US government started to fund boarding schools. And as a condition, in terms of the government to government relationship, in many cases, things like rations, things like supplies were often tied to tribal members agreeing to send their children away to boarding schools, some local, some very far away. But all of these schools had one goal, which was to assimilate these children by completely cutting off their cultural ties to not only their community, but also to their families, with the idea that if children were sent to these schools, they would learn English, they would learn discipline. This is the part where I tell you, keep in mind that in the 19th century, we did not have a concept of childhood the way that we do today, because in the vast majority of these schools, Indian children weren't necessarily receiving education as we today would consider education. In fact, boys were taught manual labor. In fact, there is some evidence that young men were farmed out, essentially used as slave labor, because of the type of work they were doing, farm work, agricultural work, mechanized work, that type of thing. While girls typically learned domestic labor, right? Cooking, cleaning, sewing, those types of things that were considered appropriate gender roles in the late 19th and early 20th centuries. But somewhere around the mid 20th century, the US government realizes the boarding schools aren't necessarily effective in what they are trying to accomplish, because you see, these children eventually age out, they eventually go back home, and then you just start the process all over again. And you're still not, or according to the US government, and those involved in this policy architecture, you're still not completely severing those ties. So what is a better way to do this? And this exists in the context of the post-World War II era, which, if you're familiar with the larger history surrounding adoption after World War II, there was a huge adoption boom in this country. We talk a lot about the baby boom, and there was an increase in the number of children born immediately after the war. But something that is lesser known or lesser talked about is the fact that the rate of adoption skyrocketed during this period, for a couple of different reasons. But it's in this context that the federal government, the BIA, Congress, come up with this thing called the Indian Adoption Project. As I just said, this is a time where adoption's booming. So you may wonder, what's wrong with this? You just said adoption's booming. This seems like what's going on at the time. Well, again, the whole goal of this adoption project was to remove Indian children not only from their families, but completely outside of their communities, to completely sever these cultural ties. And not only is, the cutoff from culture important here, but the other thing to keep in mind is, does any government, does any polity continue to exist without its membership? So this is a complete, not only removing the children and cutting them from their culture, but also a way to diminish tribes. And again, this is an assimilation project, right? We're getting children out of their families into these Western settings, hoping to cut these cultural ties, and at the same time impacting tribal sovereignty. Because tribes, their numbers are dwindling, and that's very much on purpose. So I've already mentioned this a few times. This is the ultimate goal: cut those ties, get those kids into Anglo families, get them into Anglo culture, and then we do not necessarily have to worry about what's going on with tribes. But this is why I said that, federal, state, tribal piece is really important. Because if you remember the 1960s and 70s, or if you remember the history surrounding the 1960s and 70s, this was an era of civil rights. This was an era of multiple groups, not just Black Americans, but women, American Indians, other minority groups coming forward, gathering, organizing. So as American Indians organize, as, what I would consider, and maybe this is inappropriate, but as our really large first, possibly second generation of civil rights lawyers, civil rights movement lawyers, graduate and get out into the field, they're starting to notice this very peculiar pattern when it comes to Indians and their interaction with states, or rather the state's interactions with Indians, in terms of, one, these adoption projects and how many children are being removed from the community, but also the lack of voluntariness in the removal of Indian children. The fact that it was completely okay for state workers to come, and not just state workers, let me be clear. There were a variety of nonprofit organizations who were also involved in the exact same thing as the state, and they had every right at that time to be involved in that. But people coming, showing up to your house, saying, hey, would you give your kid up for adoption? Give me your child. No, get lost. Same person next day, give me your child. No, get lost. Third day, give me your child or you're going to jail. And it's this very coercive power that existed to convince American Indian parents to either voluntarily relinquish their rights, or in some cases, start state proceedings against parents and never tell parents that these were proceedings that were happening. So their rights to their children would be terminated, and someone with a police officer would just come pick up the child and take them away. And they had no idea what was going on, no idea to defend themselves. And to be clear, in a vast majority of these cases, it seems the only thing the parent did wrong was to be Indian or to live on a reservation. And by the way, this also happened in urban areas, just the same as it did in reservation areas. But by 1978, because of the activism, and I always love to embrace the activist part of this, because I don't want to make it seem like in 1978, Congress got this brilliant idea. But no, this was the work of American Indian organizations and nonprofits and community members and activists and those civil rights lawyers who realized something was really, really wrong here. And they really started pushing and pounding the pavement. And so by the mid-1970s, Congress does have a set of hearings in which it hears, what are these problems? And this is all publicly available information today. But by 1978, they've crafted ICWA and they enact ICWA. So what does this do? It's a remedial law in the sense that it's looking back to what I consider provide equity in these situations in regard to both tribes and families, because this applies to both Indian tribes and families. And I'll get into what I mean by that in just a second. But it's also very revolutionary. In 1978, ICWA becomes the first national law to provide any sort of standards for the removal of children. The very first child welfare law, national child welfare law to exist, was in 1974. That's the Child Abuse Prevention and Treatment Act. At that point in time, not every state even had child abuse and neglect laws, or had procedures or things on their books in terms of what to do in these cases. There's a fascinating history behind that. But in many regards, ICWA is very revolutionary because it sets the stage for all of modern child welfare today. This is going to apply in certain types of child custody proceedings, like child welfare and adoption cases that involve Indian children. Now, I want to be very clear about who is an Indian child here. And in this particular case, an Indian child is someone who's under the age of 18, unmarried, and they're either a tribal member or they have the ability to become a tribal member with a parent who's already enrolled. And the reason I draw out that definition, we're not talking about people who, appear in court and say, well, my grandma was a princess of this tribe, therefore I'm Indian. This law does not cover that situation. This law is very focused on the child's political status as a tribal member, because this law fits in that paradigm of the government to government relationship and how the federal, state, and tribal governments interact. It also provides protections to Indian tribes and families alike. And that's what's really unique about ICWA. It's sometimes what really throws people off, because when I'm talking about adoption, child welfare, people don't tend to think, okay, tribal government, or they don't see how this is a tool of Indian law. It seems to be just about families. On the flip side of things, for those of us who study, practice, or engage Indian law, we tend to see ICWA only as a tool of Indian law. But it's actually both, because its day-to-day implications impact tribal sovereignty and also impact what happens with Indian families and how Indian families can exist, and how and the choices that parents can make. There's a quick note that I'd provide you on child welfare, because I find this interesting. So child welfare, if you've heard that phrase, can mean a couple of things, right? It can mean the safety and well-being of a child, or it could be used to connotate the system, the child welfare system. And that's what I'm talking about here, is a child welfare system. So the child abuse and neglect cases that exist in our court systems. So we're talking about state involvement, but here's what I find particularly interesting. Abuse and neglect exist in our laws in the same sentence usually. It's usually called child abuse and neglect, so indicating that they're the same thing. Somewhere near 75% of child welfare cases today, modern child welfare cases in the US nationally, are neglect cases. They're not abuse cases. Now, what's the distinction there? Because I just told you in the law, they typically say child abuse and neglect. Neglect is not abuse. It is, and I draw this distinction because when you hear someone's in the child welfare system, there's an automatic sense that that person is abusive. They're a horrible person. They've done something awful. But neglect typically runs concurrent with issues of poverty. So things like having a dirty or an uninhabitable house. Things like not being able to feed your children, clothing issues. And actually, I think, and this is my sense, I don't have statistics or data on this, even in a lot of substance abuse cases where maybe a parent is using a substance, those aren't all abuse cases. Usually what tends to happen is the parent in some way has neglected the child. And I know that may be a fine line or a fine hair to split, but I think it's always important to just have this understanding that when we say child welfare, we're not talking about a system full of monstrous parents. We are talking about a system largely filled with parents who simply don't have the resources they need in order to raise their families in a way that's appropriate under state law and under state surveillance. So I'll keep moving because I think I'm running short on time here myself. So ICWA and Indian tribes. So when ICWA enacted, or excuse me, when Congress enacted ICWA, it did so as part of its trust responsibility to tribes. So it's the fact that the federal government has a special obligation to Indian tribes in the US because the tribes predated the US's existence. As Professor Hedden-Nicely mentioned, we have a series of treaties. Not all tribes have those treaties, but some do. So the US does have special obligations to tribes. So in enacting this law, Congress relied on that obligation. This allows tribes to protect their members and their membership, specifically by providing for tribal participation. And there's a few different ways in which tribes can get involved. But I think the most important way is to understand that in child welfare cases especially, this provides a mechanism for tribes to be involved, to provide services to families, right? Because I just mentioned the whole, issues surrounding neglect and poverty. Sometimes tribes can and do provide better and more appropriate services to families that they're seeing. And also, it's not on this particular slide here, but the one thing you may have heard about ICWA is its placement preferences, which I will get into here shortly. But it allows tribes to be involved in decision-making surrounding where children should be placed, trying to keep children with their families, and if not with their families, maybe with another tribal member or somewhere that the tribe feels is appropriate for their member to be. So in terms of what it does for families, it provides heightened protections for families in child welfare cases. The types of standards and protections I'm talking about for non-Indians at large didn't exist until 1980. The ones that ICWA provides are actually just a little bit more heightened to ensure that courts aren't rubber stamping simple decisions or observations by state workers. But it also requires heightened protections for people who want to place their children for adoption. I think it's always important to emphasize that people have agency. ICWA absolutely does not stop Indian parents who wish to place their children for adoption in doing so. What it does do for those parents is ensure that they're not being coerced into placing their children for adoption, that they understand they're placing their children for adoption. In this short period of time, I could not possibly get into the ways in which coercive tactics have historically been used on Indian peoples, from things like, sign this paper, it's blank, sign it, this is what it is, and a person not understanding that they're literally signing a paper to terminate their rights, to other things in other realms, such as, and this is, I think this is important also, but in the area of sterilization, which is something I've also studied, having doctors tell women that you can have a hysterectomy and you can come back for a uterus transplant. So there's a lot, which is obviously not a real thing. So there is a lot of different forms of coercion that has historically been levied at Indian families. So ICWA, in the sense of child welfare and adoption and placing children out of the home, tries to limit those coercive practices. And it also provides placement preferences. So if a child has to be removed from their home, or if they are placed for adoption, it actually provides a list saying that first you should consider extended family, you should then consider tribal members, and then other tribal approved placements. Now, again, there's always exceptions because the law itself actually says absent good cause to the contrary, meaning you can rebut this placement, but ICWA itself does provide a specified list of how you should consider placing this child. This is what ICWA is best known for, because folks who do child welfare policy know that children who are placed with their family members or somewhere within their community tend to have better outcomes than children who are placed in stranger foster care or who are adopted to strangers. And in fact, my dear friend Sandy Whitehawk has just written a book on her specific experience with being adopted as an Indian child pre-ICWA. And not only the abuse that she faced within her adoptive family home for being Indian, but also speaking about the work in healing and repatriating, and how difficult that can be for people who are not only just removed from their community and placed with non-Indians, but have all legal and social connections to their tribe completely terminated. It's quite traumatic. So in my last minute or so here, I just want to mention a little bit about what's going on with ICWA and why I would focus on that today. So there's currently a case before the U.S. Supreme Court called Haaland versus Brackeen. This particular case provides challenges to ICWA, constitutional challenges to ICWA. So we have individual parties. So there are 3 adoptive couples plus 1 biological mother who are arguing how ICWA has impacted their ability to adopt children who they wish to adopt, or in the case of the biological mother, how it has impacted her ability to choose her preferred adoptive family for a child. The state party, we started with 3 state parties. Now it's just down to Texas. But the state party is actually arguing that ICWA provides an additional burden on their state child welfare system. Yes, state child welfare systems are notoriously underfunded. But the interesting thing about Texas is they've long been in court. They have a very long ongoing court case in terms of their child welfare system and not providing services to children. So they have a pretty sordid history in terms of not wanting to provide services or fund services in that particular state. But they're now arguing that ICWA is an additional burden on their state child welfare. And tribes and federal government are on the same side in this. And this is just sort of their rebuttal to these arguments. But I think what's most important here are their arguments about the protection of tribal culture and how ICWA remains in the best interests of Indian children. Again, trying to keep children with family, emphasizing how that's important, because most state laws do not emphasize that at all. I think only 1 or 2 states have laws that say if a child has to be removed from their home, that the state should first consider family. In the vast majority of cases, the state will then put the child in stranger foster care. So that's one thing that makes ICWA unique. And these are the 3 major challenges, which are whether Congress ever had the ability to pass ICWA, whether Congress commandeered state law when it passed ICWA, so that's a basic 10th Amendment argument, and whether ICWA is impermissibly race-based, meaning, does ICWA focus on Indian children as a race? And if so, whether or not the Supreme Court should reevaluate its constitutionality on that particular basis. So this case was just argued on November 9th. As such, I do not have any updates or anything to tell you about the case beyond it has been argued. I feel somewhat safe in saying that we should have an opinion by June, unless it gets has to get re-argued. We did have a case like that a few years ago that had to go through that process. But yes, that is what I have in terms of ICWA and Brackeen, and thank you all for joining and listening. And I'm sure we'll take your questions now.
Thank you so much to both of our speakers. We currently have 2 questions in the chat. Please feel free to add others as well. So Earl Bennett is asking Professor Hedden-Nicely, how does the Dawes Act of 1887 factor into the agreements under the 1855 and 1863 treaties with the Nez Perce?
Yeah, great question, Earl. So for those of you that aren't familiar, the Dawes Act, also known as the General Allotment Act, was a law that was passed in the late 1800s. And essentially what it did was it developed a policy where that caused the United States to enter into negotiations with tribes, or in some cases to do this unilaterally without the permission of the tribes, to break up a reservation. Reservations were held in common by the tribe for the benefit of its members, to break that reservation up and to allot to each individual tribal member a certain amount of land. It was usually between 80 and 160 acres of land. And then in some cases, like for example, on the Coeur d'Alene Reservation, and I believe this is also true for the Nez Perce Reservation, any land after every tribal member was allotted their allotment, any land that was left over was declared surplus and made available to non-Indians through the homestead laws. In addition to that, the land was held in trust for a certain amount of time, but then it would eventually go out of trust. And then it would be subject to state taxation. It would also be subject to, it could be used as collateral for borrowing and as a result of sharp practices, a lot of land was lost. Tribal members that had never paid taxes, had never understood the tax system, lost their land to tax sales. And so as a result of that, many reservations in the United States are what are referred to as checkerboarded, which is to say some of the land is owned by the tribe, but then a lot of the land is owned by non-Indians. For example, the Coeur d'Alene Reservation is about 2/3 owned by non-members, 1/3 owned by either the tribe or its members. The Dawes Act in and of itself did not change the governmental structure of tribes. And so tribes still had the ability and the right to govern within their boundaries. However, it did complicate matters for under what circumstances they can and they cannot govern. And if people are interested, and I can get into that, but in the interest of allowing more questions to be answered, I'll sort of leave it there. What I'll say is that for example, after 1863, and then I believe it was 1893, when the reservation was when the Nez Perce reservation was allotted, the exterior boundaries of the reservation continue to exist. That means that everything within that reservation continues to be Indian country for purposes of federal jurisdiction versus state jurisdiction, and then it complicates, but it does not mean that the tribe does not continue to have jurisdiction within that reservation.
And another question for you, Professor Hedden-Nicely. This is from Nancy Cheney, who asks, could you please speak to treaty protections and tribal sovereignty relative to social and environmental justice? How do tribes and the EPA work together to respect sovereignty while protecting the health and well-being of tribal members who live on low-income reservations that willingly or unwillingly risk exposure to environmental contaminants?
Thanks, Mayor Cheney. The answer to your question is that oftentimes the EPA does not do that very well. But I also think that the EPA does do an excellent job. There's a series of as a result of this segues nicely into sort of some of the stuff I was just talking about. But as a result of the Dawes Act and the fact that not all land within a reservation is owned by tribes, that affects their ability to govern particularly non-Indian conduct within the reservation, which has the trickle-down effect of if non-Indians are doing things that affect human health on the reservation, just pursuant to U.S. Supreme Court precedent, that significantly hamstrings the tribe's ability to do anything about that. Congress has come back in and has recognized that tribes need to have that ability. And so they've passed provisions in both Clean Water Act, Clean Air Act, and other environmental statutes that essentially recognize that tribes will be treated in the same manner as states for the purposes of those statutes. And so, for example, Coeur d'Alene tribe has treatment in the same manner as a state for clean air and clean water. And so they're able to promulgate their own water quality standards and their own clean air standards and enforce those standards against anyone within the reservation. And that's one example of Congress, at least, coming in and recognizing that tribes need to be able to have this governance authority within their own homelands, and recognizing that tribes and creating a mechanism whereby tribes can do that. For contamination or for environmental harms that have already taken place, the primary mechanism that tribes have at their disposal is CERCLA, or the Superfund statutes. And those essentially allow, in certain circumstances, for tribes, either on their own or along with EPA and Department of Interior, Department of Agriculture, to sue polluters and try to recover money in order to either restore natural resources, restore human health, those sorts of things. And so the big example in our neck of the woods is the Silver Valley, whereby the Coeur d'Alene tribe sued, I believe it was 8 mining companies in the Union Pacific Railroad, negotiated settlements they recovered around $750 million. And now that money is going towards, first, human health issues up in the Silver Valley, but then secondarily and towards natural resources restoration to try to protect tribes. Unfortunately, EPA, as well as all other federal agencies and state agencies, they're political animals. And so their level of commitment to tribes and tribal sovereignty sort of ebbs and flows depending on who's in charge.
We have a couple comments, not questions. One was about the recording. These are made available on our YouTube page for the League of Women Voters and then put up on our website. I've put my email in the chat though, if anyone wants it emailed directly to them. And we really thank our speakers for letting us record this talk because we know so many people watch our recordings later. And then Earl noted as well that we should do more of these, maybe focusing on some other issues as well. We could probably do these for years on all of the different topics. So I appreciate that suggestion, and you can tell that there's a lot of interest on these topics. I don't see other questions in the chat, so I just want to again thank both of our speakers for taking time out of their busy schedules to speak with us on these issues. As Don noted, just an introduction to some very important topics that should be on all of our radars. And thank you to Don for organizing this talk today. I'll share my screen to preview for you next week's talk. Next week's talk will be in person. It is in the Arts Workshop room of the 1912 Center here in Moscow, featuring one of our league board members and retired family physician, Dr. Connie Brum, who will be speaking on the topic of pregnancy and abortion. This is not coming from the legal perspective like we're discussing today, but from her experiences as a physician navigating the legal and political environment. So that is where we are heading for next week's speaker series talk sponsored by the league. I'll go ahead and stop our recording now. And again, just thank you everyone for being here. We really appreciate it.